I never thought a simple windmill would destroy my peaceful life in Pine Ridge, Colorado. But here I was, standing in my driveway holding a certified letter that threatened legal action if I didn't remove the beautiful turbine spinning gracefully on my property within 30 days. My name is Xavier, and I had moved to this mountain community 6 months ago after selling my tech startup in Denver. At 42, I wanted peace, clean air, and the freedom to live sustainably. The 3-acre property I purchased on Meadowview Lane seemed perfect. It sat on the eastern edge of the Sunset Hills subdivision, with sprawling views of the Rockies and enough land to pursue my dream of off-grid living. The windmill had been installed just 2 weeks ago, a sleek 15-foot turbine that generated enough electricity to power my entire home and then some. The letter came from Patricia Henderson, president of the Sunset Hills Homeowner Association. I had heard whispers about Patricia from my neighbor, an older gentleman named Roger who lived a quarter-mile down the road. He warned me that she ran the HOA like a military operation, nitpicking every minor detail from mailbox colors to the exact shade of beige allowed on house exteriors. I had shrugged off his concerns at the time. My property was technically within the subdivision boundaries, but it sat far enough out that I figured the HOA wouldn't care what I did. I was wrong. The letter cited Section 12, Paragraph 8 of the HOA covenants, which apparently prohibited structures that created visual disruption or detracted from the natural aesthetic of the community. The windmill, according to Patricia, was an eyesore that violated these terms. I had 30 days to remove it or face daily fines starting at $200 and escalating from there. I reread the covenant document that night, sitting at my kitchen table with a glass of bourbon. The language was vague and subjective. What constituted a visual disruption? Half the houses in the subdivision had satellite dishes. The Martins 3 streets over had installed a massive above-ground pool that looked like a blue tumor on the landscape. Yet somehow my windmill, which generated clean energy and actually served a purpose, was the problem. I decided to attend the next HOA meeting, scheduled for Thursday evening at the community center. Maybe I could reason with these people, explain the benefits of renewable energy, show them that the windmill was actually an asset to the neighborhood. I spent the next 3 days preparing a presentation, complete with data on energy savings, environmental impact, and property values in communities with green infrastructure. Thursday arrived with typical Colorado sunshine, the kind of brilliant blue sky that made you forget winter existed. I drove to the community center, a modest building near the subdivision entrance, and parked among a dozen other vehicles. Inside, about 20 residents sat in folding chairs facing a long table where Patricia Henderson held court. She was exactly what I expected. Mid-50s, with perfectly styled blonde hair that defied gravity, wearing a cream-colored pantsuit that probably cost more than my monthly mortgage payment. Her expression was Chinese letter, set in that peculiar smile that never reached her eyes, the kind customer service representatives wore when they were about to deny your claim. Flanking her were 2 other board members, a balding man named Gerald who looked perpetually confused, and a younger woman named Stephanie who seemed more interested in her phone than the proceedings. Patricia called the meeting to order with a sharp rap of her gavel. They dispensed with routine business quickly, approving minutes and discussing upcoming social events. Then, Patricia's gaze found me in the 3rd row. Before we proceed to new business, I believe we have a guest. Xavier, would you like to address the board regarding your covenant violation? I stood, clutching my folder of materials. Yes, thank you. I received your letter about the windmill. I was hoping we could discuss this reasonably. I have information here about the benefits of wind energy and how it actually increases property values in progressive communities." Patricia's smile tightened. "Mr. Xavier, this is not a debate about renewable energy. This is about following the rules that every homeowner in this subdivision agreed to when they purchased their property. You signed the covenant documents. You acknowledged that you would abide by our standards." "I understand that, but the language in Section 12 is vague. It talks about visual disruption, but that's subjective. My windmill is functional, environmentally friendly, and frankly, it's beautiful. It represents progress and sustainability." A few people in the audience murmured agreement. I noticed Roger giving me a subtle thumbs up from the back row, but Patricia was undeterred. "The board has determined that your structure violates our covenants. We have received complaints from multiple residents who find it unsightly. The decision is final. You have 26 days remaining to remove it, or fines will begin accruing." "Complaints from who?" I asked, my frustration building. "I would like to know who specifically objects to it." "That information is confidential," Patricia replied smoothly. "Now, if there is no further discussion, we will move on to the next item." "There is further discussion," I said, my voice rising slightly. "You cannot just arbitrarily decide what is and is not acceptable without clear standards. I want to appeal this decision." Gerald, the Balding Board member, shuffled some papers and cleared his throat. "According to our bylaws, appeals must be submitted in writing within 10 days of the initial notice. The appeals committee will review it and make a recommendation to the full board." "Fine," I said. "I will submit an appeal, but I want everyone here to know that this is not about aesthetics. This is about control. This is about one person deciding what is acceptable for an entire community without any real justification." Patricia's expression hardened. "Mr. Xavier, I suggest you watch your tone. Personal attacks against board members will not be tolerated. This meeting is adjourned." She rapped the gavel again, and people began filing out. A few residents approached me afterward, offering words of support. A woman named Jennifer said she thought the windmill was innovative. A younger couple, the Thompsons, mentioned they had considered solar panels but decided against it after hearing how difficult Patricia made things for anyone who deviated from her vision of suburban perfection. Roger caught up with me in the parking lot. "Told you she was impossible," he said, lighting a cigarette. "Patricia has been running this HOA for 8 years. She treats it like her personal kingdom. Last year she tried to fine the Johnsons for having the wrong shade of gray on their shutters. Can you believe that? Gray. She said it was too dark and created a visual imbalance." "What did they do?" I asked. "Repainted them." Everyone eventually gives in because fighting the HOA costs money. Legal fees add up quick, and Patricia knows it. She has the association's funds to hire lawyers. Most individual homeowners do not want that hassle. I drove home fuming, but determined. I was not going to be bullied into removing something that I had every right to have on my property. That weekend, I consulted with a real estate attorney in Colorado Springs named Michael Brennan. His office was in a downtown high-rise with views of Pikes Peak, and he had a reputation for taking on HOA disputes. Michael listened to my story, reviewed the covenant documents, and leaned back in his leather chair. "HOAs can be tricky," he said. "They have broad authority to enforce covenants, but those covenants cannot be arbitrary or discriminatory. The key is whether the windmill actually violates the specific language of the covenant. Section 12 talks about visual disruption and maintaining natural aesthetics," I said. "But there is no objective standard. It is all subjective." "Exactly, and that is where we can challenge them. If the covenant language is too vague to be reasonably understood and applied consistently, a court might find it unenforceable. We would need to show that the HOA is applying the rule inconsistently, or that the rule itself is unreasonably broad. What about the other structures in the neighborhood? The satellite dishes, the pool, decorative statues. Why are those acceptable but my windmill is not? Michael nodded. That's called selective enforcement, and it's a strong argument. If we can document that the HOA allows similar or more obtrusive structures while singling out your windmill, we can make a case for discrimination. How long would this take? Months, possibly longer, and it will cost you. Legal fees in HOA disputes can run $10,000 or more, depending on how aggressively they fight. But if you win, you can often recover those fees from the association. I left Michael's office with mixed feelings. I could fight this, but it would consume time, energy, and money. Part of me wanted to just remove the windmill and avoid the hassle. But another part of me, the part that had built a successful business by refusing to back down from challenges, rebelled against the idea of letting Patricia Henderson dictate what I could do on my own property. I submitted my written appeal on Monday, detailing all the reasons why the windmill should be permitted. I included photographs of other structures in the neighborhood, cited studies on property values and renewable energy, and argued that the covenant language was unconstitutionally vague. I even threw in some Colorado case law that Michael had mentioned, cases where courts had sided with homeowners against overly restrictive HOAs. 2 weeks later, I received the appeals committee's response. It was brief and unsatisfying. The committee upheld the board's decision. The windmill had to go. I now had 12 days before fines would start. I called Michael Brennan and told him to proceed with litigation. He filed a complaint in Boulder County District Court seeking declaratory relief and an injunction against the HOA's enforcement action. The legal papers were served on Patricia Henderson personally, and according to Michael, she was not pleased, but filing the lawsuit bought me time. The HOA could not impose fines while the legal action was pending. Michael explained that we would have a hearing in about 6 weeks where a judge would decide whether to grant a preliminary injunction. In the meantime, my windmill kept spinning, generating power and apparently generating rage in Patricia Henderson. She started showing up at my property unannounced. The first time, I was working in my garden when her white Lexus SUV pulled into my driveway. She got out wearing sunglasses and another designer outfit, this one in pale pink. "Mr. Xavier, I wanted to see this so-called windmill for myself," she said, walking past me without invitation. "You are on private property," I said, standing up and brushing dirt from my hands. "I did not invite you here. This is an HOA matter. I have the right to inspect properties for covenant compliance." "No, you do not. You have the right to observe from public streets or common areas. You cannot trespass on my property without permission. I am asking you to leave." Patricia turned to face me, her expression icy. "You are making a huge mistake, Mr. Xavier. This lawsuit will cost you everything. The HOA has deep pockets and excellent legal representation. You cannot win." "We'll see about that. Now please leave before I call the sheriff." She left, but it was not the last time she appeared. Over the next few weeks, Patricia drove by my property at least a dozen times, always slowing down to stare at the windmill. She took photographs from the road. She measured distances with a laser rangefinder. She was building her case, and she was making sure I knew it. The preliminary injunction hearing arrived in early October. The courthouse in Boulder was busy that morning, with multiple cases being heard. Michael and I sat in the courtroom waiting for our turn, while Patricia sat across the aisle with the HOA's attorney, a stern-looking woman named Rebecca Foster who specialized in community association law. When our case was called, both sides approached the bench. Judge Marion Caldwell, a no-nonsense woman in her 60s with reading glasses perched on her nose, reviewed the file. "This is about a windmill?" she asked, looking up. "Yes, Your Honor," Michael said. "My client installed a small wind turbine on his property for residential power generation. The HOA claims it violates a vague and overly broad covenant restriction. We are seeking an injunction to prevent the HOA from imposing fines while we litigate the underlying covenant interpretation." Rebecca Foster stepped forward. "Your Honor, this is a straightforward covenant enforcement matter. Mr. Xavier agreed to abide by the community standards when he purchased his property. The board has determined that his structure violates those standards. The association is entitled to enforce its rules." Judge Caldwell looked at me. "Mr. Xavier, why did you install this windmill?" I had not expected to be addressed directly. "Your Honor, I moved to Colorado to live more sustainably. The windmill generates clean energy and reduces my carbon footprint. It is functional, safe, and in my view, aesthetically pleasing. I believe the HOA is singling it out not because it is actually disruptive, but because the board president personally dislikes it." "And you have evidence of selective enforcement?" the judge asked, turning to Michael. Michael presented our photographs and documentation showing satellite dishes, the above-ground pool, decorative yard art, and other structures that had never been challenged by the HOA. He argued that the covenant language was too vague to provide adequate notice of what was prohibited, and that the HOA was applying it arbitrarily. Rebecca Foster countered that those other structures were either grandfathered in or had received prior approval. She claimed the windmill was different because it was taller, more visible, and more intrusive. Judge Caldwell listened to both sides, asked several pointed questions, and then announced her decision. "I am going to grant a preliminary injunction. The HOA is enjoined from imposing fines or taking enforcement action against Mr. Xavier pending resolution of the underlying dispute. However, this is not a ruling on the merits. Both parties will proceed with discovery, and we will have a full hearing on the covenant interpretation issue. I am encouraging both sides to consider mediation. These HOA disputes tend to be costly and time-consuming for everyone involved." Michael and I left the courthouse victorious, at least temporarily. The windmill could stay, and I would not be fined while the case proceeded. But Rebecca Foster stopped us in the hallway. "This is not over, Mr. Xavier," she said coldly. "We will prevail at trial, and when we do, you will be responsible for removing that windmill and paying our legal fees." "We'll see," I replied, trying to match her confidence. The next several months were consumed by discovery. Both sides exchanged documents, took depositions, and built their cases. I learned more about HOA law than I ever wanted to know. I also learned that Patricia Henderson had a history of aggressive enforcement actions. Several former residents had been targeted over minor infractions. One family had been fined over $5,000 for having a trampoline in their backyard that was allegedly visible from the street. They eventually removed it to make the fine stop. During Patricia's deposition, Michael pressed her on the selective enforcement issue. Why were satellite dishes acceptable but not a windmill? Why was the Martins pool permitted but not my renewable energy installation? Patricia remained composed, insisting that each situation was evaluated on its individual merits. The windmill, she claimed, was uniquely problematic because it was visible from the subdivision's main scenic overlook. a small park area near the western boundary of Sunset Hills that offered panoramic views of the Rockies. "The Overlook is one of our community's most treasured amenities," Patricia said during her deposition. "Residents go there to enjoy unspoiled mountain vistas. Mr. Xavier's windmill is clearly visible from the Overlook, and it disrupts that experience." This was the first time anyone had mentioned the scenic Overlook as a specific concern. Michael and I visited the location after the deposition. It was a small park with a few benches, a gazebo, and indeed, impressive views of the mountains. I could see how my windmill, about half a mile to the east, would be visible from there. It was a tiny speck on the horizon, but technically visible. "This gives me an idea," I said to Michael as we stood on the Overlook. "If she's so concerned about preserving views from this park, I wonder how she would feel if those views were blocked entirely." Michael raised an eyebrow. "What are you thinking?" I started researching property records that night. The scenic Overlook was on HOA common land, but the property directly adjacent to it, on the eastern side, was privately owned. It was a vacant lot, about 2 acres, that had been on the market for years. The owner lived in Texas and had apparently purchased it as an investment but never developed it. I contacted the owner through the listing agent. His name was David Morrison, and he was eager to sell. The lot was not worth much because it sat on a slope and had challenging topsoil conditions for building, but it was perfect for what I had in mind. I made an offer of $75,000, well below the asking price of $120,000. David countered at $90,000. We settled at $82,000. I closed on the property in late February, 7 months after the initial windmill dispute began. The trial was scheduled for early May. Michael was confident in our case, but he also warned me that judges could be unpredictable, especially in HOA matters where community interests were weighed against individual property rights. I spent March and April developing my new property. I obtained all the necessary permits from Boulder County for what I was about to do. Everything was completely legal by the book and well within my rights as a property owner. I hired a landscaping company to plant trees along the entire eastern boundary of the vacant lot, the side that faced the scenic Overlook. Not just any trees, but fast-growing evergreens. Leyland cypress, to be specific. They were already 10 feet tall when planted, and they would grow another 3 to 4 feet per year. I planted them in a dense row, spacing them close together to create a continuous wall of greenery. Within 2 weeks, the trees were in place. They effectively blocked the view of the mountains from the scenic Overlook, at least partially. From certain angles, you could still see portions of the vista, but the majestic panoramic sweep was gone. Instead, visitors to the Overlook now saw a wall of green trees. Patricia Henderson noticed immediately. I was working near the property line when I saw her SUV pull up to the Overlook. She got out, walked to the railing, and stopped dead. I could see her face redden even from a distance. She pulled out her phone and made a call, gesturing angrily at my trees. 20 minutes later, she was at my front door. I answered with a smile. "What have you done?" she demanded, practically trembling with rage. "I planted some trees," I said calmly. "On property that I own. Is there a problem?" "You know exactly what you have done. You have destroyed the Overlook. You have ruined the views that our residents cherish. This is deliberate sabotage." "Patricia, I simply made a landscaping decision on my private property. The same private property rights that I am exercising are the same rights I was exercising when I installed a windmill on my other property. If my windmill is such a visual disruption to your Overlook views, I figured I would save you the trouble of looking at it. Now you cannot see it at all." Her eyes narrowed. You think you are clever. You think this will somehow help your lawsuit. But all you have done is prove that you are a vindictive, petty man who has no respect for this community. I have tremendous respect for this community, I replied. What I do not respect is selective enforcement of vague rules by an HOA president who thinks she can bully people into submission. Now, if you will excuse me, I have work to do. She left, but I knew this was far from over. That evening, I received a call from Michael Brennan. The HOA had filed an emergency motion seeking an injunction against the trees. They claimed I had acted in bad faith to intentionally harm the community and diminish property values. Can they do that? I asked. They can file whatever they want, Michael said. But they would have to show that you violated some law or covenant. Did you get proper permits for the trees? Every single one. Boulder County approved everything. I even had a soil engineer evaluate the slope to ensure proper drainage. Then they do not have a case. You have every right to landscape your own property. The fact that it happens to block their view is not illegal. There is no law that says you must maintain scenic views for other people's benefit. The emergency hearing was scheduled for the following week. Judge Caldwell did not look pleased to see us again. Miss Foster, what exactly is the emergency here? She asked the HOA's attorney. Your Honor, Mr. Xavier has engaged in retaliatory conduct designed to harm the homeowner association and its members. He purchased property adjacent to our community's scenic Overlook and planted trees specifically to obstruct the views. This is clearly bad faith conduct related to the pending litigation. Your Honor, Michael responded, Mr. Xavier purchased private property and made lawful improvements to it. He obtained all required permits. The HOA has no legal interest in that property and no right to control how it is landscaped. The fact that the trees happen to block views from the Overlook is not illegal. Property owners routinely plant trees that affect sight lines. That is not retaliation. That is landscaping. Judge Caldwell rubbed her temples. Mr. Xavier, did you plant these trees to get back at the HOA? I stood up. Your Honor, I planted the trees because I wanted privacy on my new property. I also admit that I found it ironic that the HOA's entire objection to my windmill was based on it being visible from the Overlook. If that view is so important to them, I thought perhaps they would appreciate not having to look at my property at all. A slight smile flickered across the judge's face. So you are saying this was not retaliation, but rather accommodation? Exactly, Your Honor. Judge Caldwell denied the HOA's emergency motion. She ruled that I had every right to landscape my property as I saw fit, and the HOA had no standing to challenge it. She also moved up the trial date on the Windmill case, clearly tired of dealing with this dispute. The trial began 3 weeks later. It lasted 2 days and involved extensive testimony about covenant interpretation, property rights, and community standards. Michael presented our evidence of selective enforcement, showing that numerous structures existed in the subdivision that could arguably violate the same vague covenant language that the HOA was using against my windmill. We also presented testimony from real estate experts who stated that renewable energy installations typically increase property values, not decrease them. One expert noted that Colorado had specific laws protecting solar access, and while those laws did not explicitly cover wind turbines, the public policy behind them supported sustainable energy installations. Patricia Henderson testified at length about her vision for the community, the importance of maintaining aesthetic standards, and her belief that the windmill was inconsistent with the character of Sunset Hills. She was polished and professional on the stand, but Michael managed to get her to admit that no other resident had ever been denied permission to install renewable energy equipment because no one else had ever asked. "So Mr. Xavier is the first resident to request wind power?" Michael asked. "Yes," Patricia admitted. "And rather than develop clear guidelines for such installations, the board simply denied his request outright. We determined it violated existing covenants. But those covenants do not specifically mention wind turbines, correct? They mention visual disruption. They also do not specifically mention satellite dishes, above-ground pools, or decorative statues, correct? Yet those are permitted." Patricia bristled but had to concede the point. The testimony about the trees came up during cross-examination. "Rebecca Foster tried to paint me as vindictive and hostile to the community, someone who would rather destroy shared amenities than compromise. Mr. Xavier, you purchased property adjacent to the community Overlook specifically to plant trees that would block the views, correct?" Rebecca asked. "I purchased property to expand my holdings and to create a privacy buffer," I responded. "The fact that it happens to be near the Overlook is incidental. Is not it true that you only purchased that property after learning that the HOA's objection to your windmill was based on its visibility from the Overlook?" "I purchased the property after learning that, Miss." Henderson was more concerned with hypothetical aesthetic impacts than with actual community benefits. "Yes. And you planted the trees to retaliate against the HOA for enforcing its covenants." "I planted the trees because they are my trees on my land, and I wanted them there. If the HOA wants to argue that I cannot plant trees on my own property, then we are proving my entire point about selective enforcement and overreach." Judge Caldwell took the case under advisement after closing arguments. She promised a written decision within 30 days. Those 30 days were tense. Patricia continued her drive-bys, now documenting both the windmill and the trees. She started showing up at my other property line too, measuring things and taking notes. It was harassment, plain and simple, but Michael advised me to document it rather than confront her. The HOA also began citing me for minor infractions. I received a notice that my mailbox was the wrong shade of black. Another notice claimed my lawn exceeded the maximum permitted grass height by a quarter inch. A third notice said my house numbers were not properly illuminated. Each notice carried potential fines if not corrected within 10 days. "This is retaliation," I told Michael over the phone. "She is harassing me. Document everything. Take photos, keep records, save all the notices. If this goes back to court, we want to show a pattern of retaliatory conduct by the HOA." The decision arrived on a Wednesday afternoon in early June. Michael called me immediately. "We won," he said, his voice excited. "Judge Caldwell ruled in our favor on every point. The covenant language is too vague to be enforceable as applied to your windmill. She found selective enforcement. She even cited the tree incident as evidence that the HOA's real motivation was not aesthetic standards but personal animosity. The injunction is made permanent. You can keep your windmill." I felt a wave of relief wash over me. 13 months of fighting, tens of thousands in legal fees, countless hours of stress, and it was finally over. "What about their legal fees?" I asked. "Can they still come after me for costs?" "No. Under Colorado law, when an HOA loses a covenant enforcement case due to vagueness or selective enforcement, they cannot recover fees. Better yet, we are filing a motion for you to recover your fees from the association." The judge's ruling specifically mentioned the HOA's bad faith conduct. "I think we have a good shot." The ruling was delivered to the HOA the same day. According to Roger, who remained my reliable source of neighborhood gossip, Patricia Henderson had a complete meltdown during an emergency board meeting that evening. She allegedly threw papers, shouted at the other board members, and blamed everyone but herself for the loss. But Patricia was not done. A week after the ruling, I received another certified letter. This one informed me that the HOA was amending its covenants to specifically prohibit wind turbines, and that my windmill would be grandfathered in, but could not be replaced or significantly modified without board approval. Michael laughed when I showed him the letter. They can amend their covenants all they want, but it does not affect you. Your windmill is protected by the court ruling. And honestly, good luck getting the required homeowner vote to amend the covenants. She would need at least 75% approval, and I am guessing a lot of residents are pretty fed up with her after this expensive lawsuit. He was right. The amendment proposal went to a vote in July and failed spectacularly. Only 32% of homeowners voted in favor. Several residents wrote letters to the board criticizing Patricia's leadership and calling for her resignation. The motion for me to recover legal fees was heard in August. Judge Caldwell awarded me $84,000, nearly the full amount I had spent on the litigation. The HOA was also ordered to pay within 60 days or face additional interest and penalties. This created a crisis for the association. They did not have $84,000 in their operating budget. They would have to levy a special assessment against all homeowners to cover the judgment. Each household would have to pay approximately $400. The special assessment notice went out in September. Roger called me the day he received his notice. "You know this is the end of Patricia, right? People are furious. Paying $400 because she decided to wage a personal vendetta against you. There is already a recall petition circulating. They need signatures from 30% of homeowners to trigger a recall vote. Last I heard, they already have 40%. The recall vote was scheduled for October. I did not attend the meeting, but Roger gave me a full report. Patricia showed up and tried to defend her actions, arguing that she was protecting property values and community standards. But resident after resident stood up and criticized her leadership. They talked about the wasted money, the petty enforcement actions, the hostile environment she had created. The recall vote was not even close. 82% voted to remove Patricia Henderson from the board. She left the meeting in tears, according to Roger, and put her house on the market the following week. A new board was elected in November. The president was a retired engineer named Tom Richards, who had been vocally critical of Patricia's handling of the windmill dispute. One of his first actions was to establish clear guidelines for renewable energy installations. The new policy encouraged solar and wind power, set reasonable standards for placement and height, and created an approval process that was transparent and objective. Tom called me personally to apologize for the HOA's conduct. "What Patricia put you through was wrong," he said. "This association should support innovation and sustainability, not punish it. I hope you will consider staying in the community." I thanked him and said I had no plans to leave. The windmill was still spinning, producing clean energy and proving that homeowners could stand up to HOA overreach. But I was not quite done with the tree situation. The new board approached me in December about the Scenic Overlook. Tom and 2 other board members came to my house and asked if we could talk. "Look, Marcus, we know you had every right to plant those trees," Tom said, "and we know why you did it, but the Overlook really is an important community amenity. A lot of residents, people who had nothing to do with Patricia's crusade against you, are disappointed that the views are blocked. Is there any way we could work something out?" I had anticipated this conversation. "What did you have in mind?" What if the HOA purchased the property from you at a premium? You paid $82,000. We could offer you $110,000. That gives you a nice profit, and we could remove the trees and restore the overlook. I considered the offer. Part of me wanted to keep the trees just to make a point. But the new board was clearly trying to repair relationships and move forward. These were not the people who had attacked me. They were homeowners trying to clean up someone else's mess. I will sell you the property for $120,000, I said. That covers my costs, gives me a reasonable return, and includes compensation for the hassle of dealing with all of this. But I have one condition. What is that? The HOA installs a small plaque at the Overlook explaining that the views were temporarily blocked due to HOA overreach and were restored through negotiation and compromise. I want future residents to know what happened here. Tom laughed. That is fair. We can do that. The sale closed in January. The HOA removed the trees and restored the Overlook. True to their word, they installed a bronze plaque near the gazebo that read, "This scenic overlook was preserved through community dialogue and mutual respect. May it stand as a reminder that property rights and community values can coexist when we approach differences with reason rather than rigidity." I never saw Patricia Henderson again. Her house sold in February to a young family with 2 kids. Roger reported that Patricia and her husband moved to Arizona, presumably to find an HOA where she could be in charge again. My windmill continued to spin, a permanent fixture on the eastern edge of Sunset Hills. I added solar panels the following spring, further reducing my reliance on the grid. The new HOA board approved them without objection. Life in Pine Ridge returned to peaceful normalcy. I spent my time hiking, working on sustainable living projects, and occasionally consulting with homeowners from other communities who were fighting their own HOA battles. My story had apparently made the rounds in property rights circles, and I received emails from people across the country dealing with similar situations. I usually gave them the same advice Michael Brennan had given me. Document everything, know your rights, and do not back down from arbitrary enforcement. HOAs serve an important purpose in maintaining communities, but they are not dictatorships. When they overstep, homeowners have legal remedies. One afternoon in late spring, almost 2 years after the windmill dispute began, I was sitting on my deck watching the turbine spin against a backdrop of snow-capped mountains. Roger stopped by with a 6-pack of beer, and we sat together enjoying the view. "You know, you could have avoided all of this if you had just taken down the windmill," Roger said, popping open a can. I shook my head. No, I could not have, because it was never really about the windmill. It was about someone thinking they had the authority to tell me what I could do on my own property without any good reason. If I had given in, it would have just been something else next time. A solar panel, a garden shed, the color of my front door. Where does it end? Fair point, Roger said. Still, it cost you a lot of time and money. It did, but I got most of the money back. And the time? Well, some things are worth fighting for. Property rights, personal freedom, the principle that people should not be bullied by petty tyrants. Those things matter. We drank our beer and watched the sun drop toward the horizon, painting the sky in shades of orange and pink. The windmill turned steadily, its blades catching the last light of day. "Think you will ever run for the HOA board?" Roger asked. I laughed. "God, no. I have had enough of HOA politics to last a lifetime. I am perfectly happy being a regular homeowner who pays his dues and minds his own business. But you will fight back if they come after you again." "Without hesitation," I said, "but I do not think they will." The new board learned a very expensive lesson about picking fights with homeowners over stupid stuff. And that plaque at the Overlook, that is not just for future residents. That is a reminder to future board members. Before you start a war with a homeowner, make sure you have the law on your side and make sure it is a battle worth fighting. Roger raised his beer can. To windmills and blocked views. I clinked my can against his. To property rights and reasonable people. We sat there until the stars came out. Two middle-aged men who had lived through a small war in a suburban subdivision and come out the other side with friendships intact and principles defended. The windmill kept spinning, as it had through all the arguments and legal battles and petty harassment. It would probably still be spinning long after I was gone, a monument to the idea that sometimes you have to stand up for what is right, even when it is expensive and exhausting and seemingly pointless. Because in the end, it was not pointless at all. It was about drawing a line and saying this far and no further. It was about refusing to let fear of conflict prevent you from living according to your values. It was about recognizing that communities are built on mutual respect, not unilateral control. Patricia Henderson never understood that. She thought power came from rules and fines and enforcement actions. But real power comes from legitimacy, from leading people who choose to follow because they trust your judgment and respect your fairness. The new HOA board understood that. They established clear rules, applied them consistently, and listened when homeowners raised concerns. They did not make every decision everyone liked, but they made decisions that people could respect even when they disagreed. And my windmill, it became something of a neighborhood landmark. People gave directions using it as a reference point. Kids asked their parents what it was and got lessons about renewable energy. A few other homeowners even inquired about installing their own turbines, though most opted for solar panels instead. The whole experience taught me something important about America and how we live together. We love our rules and our associations and our community standards. But we also love our freedom and our property rights and our ability to tell busybodies to mind their own business. Finding the balance between those competing values is never easy, but it is essential. HOAs are not inherently evil. They serve legitimate purposes in maintaining property values and providing shared amenities. But they can become tools of oppression when run by people who care more about control than community. The key is active participation by reasonable homeowners who will not tolerate abuse of power. I never wanted to be an activist or a test case. I just wanted to generate my own electricity using wind power. But sometimes circumstances choose you rather than the other way around. When they do, you can either surrender or stand your ground. I am glad I chose to fight. 2 years, $80,000 in legal fees mostly recovered, and countless hours of frustration later, my 15-foot windmill still turns in the Colorado breeze, generating power and reminding everyone who sees it that property rights mean something. That individuals matter. That you do not have to accept arbitrary authority just because someone has a title and a gavel. Patricia Henderson moved on to terrorize some other community. The Sunset Hills HOA learned an expensive lesson about overreach, and I got to keep my windmill, my principles, and my self-respect. In the grand scheme of things, that is a pretty good outcome. As I sat on my deck that evening watching darkness fall over the Rockies, I felt a deep sense of satisfaction. Not because I had won some legal battle, though that certainly felt good, but because I had stood up for something that mattered and refused to be pushed around. Because I had drawn a line and defended it. The windmill turned steadily against the night sky, its blades silhouetted against the stars. It would turn through summer heat and winter snow, through calm days and fierce mountain winds. It would turn for years to come, a testament to sustainable energy and stubborn principle. And if some future HOA board ever decided to challenge it again, they would find the same thing Patricia Henderson found. I do not back down. I do not give up, and I will use every legal tool available to protect my rights. That windmill represents more than electricity generation. It represents freedom, independence, and the radical idea that a person should be able to make reasonable choices on their own property without interference from petty bureaucrats. That is worth fighting for. That will always be worth fighting for. And as long as that windmill keeps spinning, everyone who sees it will know that at least one homeowner refused to surrender his rights to an HOA board that forgot its proper role.